you guys know, this is about the 7th event we've done so far this year for the Federalist Society. In fact, I think we've now just about doubled what we did the 2 years prior. So,
wow. That's really good for you guys. That's really good.
Still have a few more coming.
Keep them coming.
Like I said,
that's great.
We're trying to build something here, and appreciate all y'all's help. And again, go to the Federalist Society website, fedsoc.org, little join button up in the corner. I know a bunch of you have done that. Pay the $5. There's a lot of benefits that come with that. I know I've had some of the Harvard Law Reviews, everything else here before, but you get those in the mail, and there's a lot of things you'll get as far as teleconferences and everything else. Ton of information. Plus, you can start getting in contact with some of the lawyers, like the local lawyers we have here in the Lawyers Chapter. We had Mark Ayers come talk. You were here for that talk. That was really good. But again, I'm really honored that we were able to get 2 speakers at one time of the caliber that we have here today. If you don't know who this is, over here to my left, we have Judge Pryor. He is a judge on the U.S. Court of Appeals for the 11th Circuit. He's also the chairman of the U.S. Sentencing Commission.
No, I was.
What?
I was the acting chair.
I was corrected on this earlier today.
Gotcha. So I'm not alone. Yeah.
I served for 5 years on the commission.
Gotcha. Also former Alabama Attorney General. I believe that was from 97 to around 2004. Right. Originally from Mobile, Alabama. I know went to Tulane Law School. One thing we all, of course he teaches here some as an adjunct professor. Has in a little while, I've kind of missed out on that. I wanted to take the reading law class, but I guess I'm going to miss out on that since I'm graduating. But of course, most importantly, if you remember back in 2016, was on the short list for the Supreme Court. So, big deal.
The short list. Not
there
were a lot of lists.
Yes.
There was a long list and then a longer list, but he was on the short list.
Yes.
We're friends. I like to embarrass him. He'll embarrass me. Don't worry, it's how it works.
And now to introduce Josh Blackman, Professor Blackman.
I'm not a judge. Yet, at least.
Probably never.
No. See, I told you. Lord help all of you if I am. Run.
Blackman's originally from New York City.
Oh, come on. You're selling me out?
They know me. I'm from Pittsburgh.
Okay,
so that's
fine.
Why his undergrad was at Penn State. That's kind of close to my heart there, too. I graduated the Antonin Scalia Law School.
I did.
He's the current associate professor at South Texas College of Law. Of course, Hyman. That would be right within his our Texas guys outside. And it's something very interesting is that, it's like did a shout out, for being on the short list of the Supreme Court. Professor Blackman, if you happen to watch any impeachment trial when Professor Alan Dershowitz, professor from Harvard, I think we've all heard of him, quoted his op-ed from, was it in the New York Times?
Yeah.
Yeah.
Imagine that.
On the floor of
the
the
New
Senate,
York Times
yes.
published my op-ed and Dersh quoted it. Imagine that.
And he actually, along with Professor Randy Barnett, has put out a book. It's an introduction to constitutional law, the 100 Supreme Court cases that everyone should know. I would suggest getting this book. It is getting kind of hard to find because Amazon keeps selling out of it. Great book, breaking down, again, the 100 cases you should know. But also, it has a component to it where you sign in, and they've actually filmed videos that go more in depth into each case. So it's really well.
It's good to binge watch for your final exam. Not joking.
So really, without further ado,
He also is the recipient of the Joseph Story Award from the Federalist Society National Lawyers Division for the outstanding legal scholar under the age of 40.
Very good. I have not been elected Attorney General yet, so I still think you're. How old are you elected, AG?
I was 34.
Shh. I was 34 when I became a professor, so I think you're still a couple clips ahead of me.
Yeah, and
Always.
We're here for our event right before this when we had the judge.
Judge Carroll.
No.
Yeah.
We did. It was that year before last.
Yeah.
We had Judge Carroll when they all talked about the whole Roy Moore debacle.
Yes.
No, in my brain this isn't working right now. Our last event that we had was Judge Newsom. Thank you, Kevin Newsom. I mean, like I should forget his first name. We're both named Kevin. But Judge Newsom talked about how he came into contact with Judge Pryor and how that worked out for him. Ended up being a Solicitor General and everything. So again, a lot of connections between everything, and we're very honored here at Cumberland to have them. So without further ado, I will turn it over to y'all.
Okay. Thank you so much to all of you. Our topic today is judicial supremacy. Now, what is judicial supremacy? So let's start by looking at our constitutions. You all have your constitutions handy? You don't.
Have you all heard the term judicial supremacy before?
No.
You have?
Well,
No?
I told him I wouldn't call, I promised actually.
I didn't tell him that.
Oh, Judge. So let me just read you guys the Supremacy Clause, okay? You should all know it. Very important part of the Constitution, okay? Article 6. This Constitution and the laws of the United States which we made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. So the Constitution establishes that the Constitution and federal laws and treaties are the supreme law of the land. And no one disagrees with that. Everyone agrees that much. But what about the decisions of the U.S. Supreme Court? Are the decisions of the U.S. Supreme Court the supreme law of the land? Now, we all know the court interprets the Constitution, but are their decisions themselves treated as if they're supreme law? In other words, does a Supreme Court decision act as an amendment to the Constitution? If 5 members of the court reach a conclusion saying X, is X now part of the Constitution? And if 5 justices a year later reverse it, does that X become removed from the Constitution? Now, some law students have thought about this, most students haven't. Judge Pryor and I agree on a little bit here, on this topic at least.
A lot.
A lot on this topic. Other things, not so much. Don't ask about football, right? We were in Tuscaloosa today. Did not mention football there. That would have been a very bad thing to do.
Roll Tide.
Yes, roll Tide. God, I went to Penn State. I have no standing to talk about football. 0. But we're talking today about whether this concept of judicial supremacy exists. And the starting point for our discussion is a case you all studied in con law, Marbury against Madison, right? You all studied it. You all read this in 1L. Now, I can just take a show of hands. Who here learned that Marbury invented the concept of judicial review? Ooh, a couple of hands, not so sure, right? Okay, that's not correct, but I appreciate your honesty, okay?
Yeah, sometimes students are taught that. It doesn't mean it's true. Is
Right.
What he's saying.
Right.
We both agree that's not true.
Okay, so let's talk about Marbury, right? In Marbury, as we all remember from common law, Chief Justice Marshall wrote a decision, and he found that parts of the Judiciary Act of 1789 were unconstitutional. That is, you had a statute that tried to expand the jurisdiction of the Supreme Court, and Congress couldn't do that. Why? The Constitution limited the jurisdiction of the Supreme Court. The original, I'm trying to make it simpler for them. See, he's like my professor in my ear just yelling at me, right? So when you have a statute that conflicts with a higher law, the Constitution, which one prevails? You follow the higher law. In fact, judges have a duty, I call it a judicial duty, to follow the higher law, right? That's all judicial review actually is. Courts can assess, we have to follow the higher law, and if there's a conflict, we go to the Constitution. But you don't have a decision in Marbury that actually says that the Supreme Court establishes the supreme law of the land. Marbury also doesn't say that only the judges of the Supreme Court can interpret the Constitution. Far from it. Marbury recognized a very basic aspect of our government. Every branch, every department, oh, he's got paper, every officer in our government takes an oath to the Constitution. Any of you actually worked for government before? Did you take an oath to the Constitution when you started? Do you know why you did that? Article 6, the Oaths Clause, right? It says basically, senators, representatives, state legislatures, executive and judicial officers, both in the state and federal governments, take an oath to be bound by the Constitution. When you are a member of the government, either state or federal, you have an oath to the Constitution. Every day you decide, is what I'm doing constitutional? You don't need to ask a court for permission first, right? If any of you are in law enforcement, if you want to pull someone over, you have to ask yourself, do I have probable cause? Now, a judge might disagree with you down the road, and that happens all the time. But in the first instance, you ask, what about the Fourth Amendment? Right? Let's say you're working in the county commissioner's office and you have to approve a parade permit. You say, if I deny this permit, do I violate the free speech protections? Say a church applies for a building permit to expand their house of worship, and you deny that. You say, do I violate the free exercise clause this way? Let's say you're a prosecutor and you decide to charge someone. You say, am I complying with the due process of law when I charge this person? Do I have enough sufficient evidence? Will I conduct a speedy trial? Right? Have I perhaps not given him compulsory process? Am I allowing him to confront witnesses? Right? When you're a government official, you make all these choices. Later on down the road, a court may decide that yes, you were right, or no, you were wrong. But in the first instance, individual officers make those calls. Marbury recognized this. And Marbury said each department, that is each kind of branch, each agency within government, can make decisions for themselves. This is what's known as departmentalism, right? That courts do not have a monopoly on the Constitution. What I'm saying so far should not be controversial, but you maybe never thought of it quite that way. But then why are we here talking about judicial supremacy? Well, starting in the 20th century, much, much later, the Supreme Court began to write decisions which suggested that their opinions are the supreme law of the land. That whatever a court says becomes part of the Constitution. Now, this arose in a context that maybe you might agree with it, right? And let me give you the background. The Supreme Court decided Brown versus Board of Education. This was a famous case involving school segregation. And the Supreme Court said that the doctrine of separate but equal has no place in public education. Okay, what next? Did the court say that we are ordering every single public school in the United States to desegregate? No, they did not do that. They did something different. They said, okay, let's let local courts supervise situations on the ground. And local courts can issue injunctions to local school boards to help integrate with all deliberate speed. And that was a phrase they used. All deliberate speed. Right? How'd that work out? Not well at all. School districts across the country took every measure to resist. It was in fact known as a massive resistance to integration. Perhaps the most severe resistance came in a case called Cooper against Aaron, okay, from Little Rock, Arkansas. So here's what happened. Okay, we have a conflict. A federal judge ordered the Little Rock School Board to integrate the schools. Consistent with Brown, I think that was the correct ruling, no question asked. But then a state court judge said, you know what? I don't think so. The state law says you keep the schools segregated. I don't think Brown controls the situation. As a state court judge, I'm issuing a contrary injunction. My injunction says keep the schools segregated. Right, so imagine you're a school board official. You don't want any of this problem, right? But you're sitting in a situation where judge number one, federal judge, says integrate, and judge number two, a state judge, says segregate. And how do you resolve that conflict? Right? If you ignore judge number one, they can hold you in contempt. If you ignore judge number two, they can probably hold you in contempt also of court. So you're like in between a rock and a hard place. So the only way for that resolution to happen was for the Supreme Court to get involved. Right? The Supreme Court has to get involved. And that's what the Supreme Court did. And the Supreme Court ruled that these sorts of chicanery, these tricks are not going to work, that they're not consistent with Brown. I think that was absolutely a correct decision. But then the Supreme Court went a step further. And they said, look, we are sick and tired of all these school boards dragging their feet. And we're sick and tired of these school boards playing this game of whack-a-mole, right? It's like, no, you sue us, and you have to sue us, and sue us. I have a million lawsuits, right? We said what we meant in Brown, and we meant it. We don't want to deal with all this case-by-case litigation. Just get it over with, right? So the Supreme Court says the Supremacy Clause, I read it to you earlier. When it says supreme law of the land, we are the supreme law of the land. Our decisions are the supreme law of the land. So even if you're not sued, you're bound by what we say, right? by virtue of the fact that the Supreme Court rules, you're bound by it. Now, did that work? Nope. What did Little Rock, Arkansas do after that decision? They shut down the schools. They shut down their schools for a couple of years, in fact. They rerouted funding for the public schools to private schools that remained segregated. Or they transferred ownership of the buildings to these corporations which were not bound by the 14th Amendment. And then there was litigation for another decade that had to go after these sorts of chicanery, these workarounds. But in the process of the Supreme Court trying to reach everyone, they asserted this principle of judicial supremacy, that they could reach parties not before them. There's a basic principle of federal jurisprudence, which you all know. If I sue Judge Pryor, and I'm a bad example, immunity, right? But if I sue, if he's smiling, if I wouldn't sue him, I'd lose him really quick. If I sued Kevin for some sort of tort or something, right, or a contract breach, right, and we have a judge between the two of us, that judgment does not affect you, or you, it's between the two of us, right? How can one court bind others? Supremacy says they can, and I think that this principle is not supported by history. Sure, it's not supported by Marbury, and also I think it's inconsistent with how our system of government works. Okay, but does that mean you can ignore a Supreme Court precedent? No. Why? Because you can get your butt sued and get set with damages, right? If there's a Supreme Court precedent on point, and you're a government official, and you choose to ignore that precedent, you can get sued, and your friendly local district court judge will gladly enter an injunction, and they might hold you liable for damages. Certainly attorney's fees at a minimum, right? If you flagrantly, I don't know, how flagrantly do you have to ignore a precedent to get sanctioned? I mean, you think?
No advisory opinions to that.
Oh, damn, okay. Well, I think if you flagrantly ignore a Supreme Court precedent, I think a judge could reasonably sanction you. I can go back and forth, but for sure you get hit with fees for attorney's fees. So there are ways of ensuring compliance without having this concept of judicial supremacy, right? But this concept that the Supreme Court can establish, the Supreme Law of the land I think is problematic, and I don't think it's consistent with Marbury. So now let's bring in everyone's favorite Chief Justice, no not, John Roberts, who's now thankfully out of it. He has not only one job, he doesn't have a second job, the trial's over, we can go back to our lives. I'm talking about the Chief Justice I saw on the billboard on the freeway, Roy Moore, of course. I saw these billboards from him because he's still here, I guess. He had some brush-ups with what you might call judicial supremacy, and Judge Pryor in his previous capacity was a state attorney general, your Alabama attorney general. And at one point, Chief Justice Roy Moore decided to renovate the courthouse in Montgomery. He redecorated, right, make it more feng shui, right? He decided, it gets better the second time. He decided to install this massive.
It's about the size of a washing machine.
It was, yeah. Oh, come on.
It's about the size of a big washing
Fine.
machine.
He's trying to. He installed this monument.
It was 2 tons.
It was heavy, right? In fact, I think the scuff marks are still on the floor. If you go to the building, you can still see where it was. Preview, it's not there anymore, right? But he installed basically a monument of the 10 Commandments, right? And he decided that was something that he wanted to do. Okay. He was sued, and the federal judge there entered an injunction ordering him to remove it. At which point, Judge Moore said, I disagree. I think I am right about the Constitution, that this monument does not violate the Establishment Clause. I'm going to leave it. At which point, Judge Pryor came in and said, no. Oh, Attorney General Pryor should say. The Attorney General said, no, you cannot do that, right?
Well, I prosecuted him on charges of misconduct in a state court after he disobeyed the federal injunction and after we removed the monument.
That's exactly right. He dragged it out. Was it in the dark of night he dragged it out, or in the middle of the day?
No, he drug it in the dark of night. He didn't tell the court that he was going to do it, but he had a religious ministry there, Coral Ridge Ministries, to film it all.
Oh, well, good. Glad they recorded that.
We took it out during the day.
Well, that was redecoration, right? You have to renew the courthouse. But the point is, when you have a judgment that's binding against you, that means something. So even Judge Pryor and I, who are critical of supremacy, agree on this much. You can disagree with the court, say that ruling's wrong. But once you have that final judgment against you, you should comply with it. The alternative, my friends, I think is quite ugly, where every man becomes a law unto himself, right? I don't want to live in that society, right? I can criticize the ruling, I can say that this judge screwed up, he was an idiot, he made it wrong. I'll never say that about you, Judge, right? But you can say that. But that's not the same thing as saying the Supreme Court can amend the Constitution itself. I think there's a huge distinction. Now, there's a second Judge Moore situation. This guy just keeps like the moth to the flame, right? Judge Moore had a second situation a couple of years ago.
Not the Senate race.
No, well, I'm not even going to mention that one, right? So don't remind me of that one, right? Is that going to happen again? No advisory opinions.
That would be a political opinion.
A third. That'll be for another session. So let's see, a couple we got that one. So let's move on to the second Roy Moore situation that involves supremacy. This guy is a one-trick pony, right? He finds different ways of doing the exact same thing, getting removed from office for it. He's done it twice. That's commendable, right? So the second thing about Judge Moore was involving the gay marriage litigation, the same-sex marriage litigation. You may recall that after Windsor was decided, this was a Defense of Marriage Act case. After Windsor was decided, states were sued across the country to require the government to issue licenses to same-sex couples, right? And there was a lawsuit filed down in Mobile, Judge Grenade's chambers, as a federal district court down there. She had issued an order initially against a couple of the probate judges who give these licenses, but eventually certified a class. And this class certification said that all the probate judges in the state of Alabama are obligated to issue licenses to gay couples, and they should not follow the Alabama marriage law. Okay, so if you're a probate judge in Alabama and you get that order, you may not like it, you may not agree with it, but at least you know what to do. Then the Alabama Supreme Court does something. The Alabama Supreme Court, acting in its original jurisdiction in a mandamus action, I think I got that right this time, right? Effectively says that the Alabama marriage law is still valid. A Burgerfellow that had not happened yet. The Supreme Court had not yet ruled, which is an important point. Okay? So the Alabama Supreme Court said, injunction. Judges, state probate judges, you cannot, state probate judges, mandamus, I keep saying injunction, mandamus, you are obligated to continue following Alabama marriage law. Now, at that juncture, at least for a couple of the probate judges, if not all of them, they had a conflict, right? Federal judge says do X, state judge says do the opposite of X. Now you may say, well, Josh, doesn't the federal court win? Not necessarily, right? I think both a state judge and a federal judge take the same oath to the Constitution. And I think they're each competent in their own spheres to interpret the Constitution. And thankfully, we have an institution that can help resolve conflicts between state and federal judges. It's called the U.S. Supreme Court. Okay. Now, the Alabama case was never appealed to the Supreme Court. Instead, the court decides Obergefell, which involved appeals from the Sixth Circuit. So it was Michigan, Ohio, Tennessee, and Kentucky, right? Obergefell only directly affected those states. Well, he's right. The parties from those states, specifically the state officials from those states with respect to the parties from the states. After Obergefell was decided, I think about a day later, Judge Grenade issues a judgment down in Mobile. It's what's called domesticating the judgment, right? She issues another injunction saying, okay, you guys, we have Obergefell, the Supreme Court spoke. I am now going to follow this ruling and issue an injunction against all the probate judges in the state of Alabama, saying that you are now obligated to issue these licenses. Now, does Judge Grenade's order dissolve the Supreme Court of Alabama's order? And the answer there is no. I don't think it does. I don't think she has the power to do that. So now you have the judges, the probate judges, in this tough spot. Which one do they follow? Then it gets weirder, right? The Alabama Supreme Court dismisses the appeal. And I'll leave to my good friend to decide what that actually means. But at least some lawyers in the state think that means the injunction remains in place. That is, they dismissed an appeal, but they didn't dissolve the order. And that might be right, might not be wrong, I'm not even sure. But in the middle of all this, before all this goes down, Judge Moore goes ahead and issues an opinion. And it's not a judicial decision. He, as Chief Justice, he has administrative functions, right? Basically kind of like the administrator of the state court system, which includes the probate judges. And he says to them, you still have a binding order to follow, the Alabama order. He did not mention Judge Grenade's order. Didn't even talk about it. That would have been nice if he had mentioned it. He didn't even, can you imagine you have a law review paper, right? You don't cite controlling authority. He didn't even mention it. Now, in his slight defense, he didn't have to, but he should have, right? He should have mentioned it. But he said, you have this binding order. Subsequently, he was, the court dismissed the appeal. Then he was brought up in charges of misconduct. And the misconduct complaint, if you read through it, it's very long, basically says the Supreme Court decision in Burgerfell established the supreme law of the land, right? The people who are going after Judge Moore bought into the judicial supremacy myth. So it pains me to have to defend him in even the slightest bit, but I think at least part of the allegations against him were premised on something I disagree with vigorously, which is judicial supremacy. I don't think a Burgerfell affected directly the litigation in Alabama. What affected the litigation in Alabama was Judge Grenade's order down in Mobile. That had the effect of putting the judges in this state on notice that they could no longer enforce the law, right? But I don't think that Judge Grenade's order dissolved the Alabama Supreme Court's prior order. They may have done it on their own. I can't speak to that. But you still have this dueling situation, and the Supreme Court never touched it. So my defense of Moore is so slight, but I think removal was fine. Okay, he does not deserve to be in any office of public trust. I think I'm okay with saying that. But the manner in which they charged him based on supremacy, I think that part was flawed. I think that I'll leave it there.
Okay.
And turn over to my good friend Judge Pryor, who will beat me over the head with that bottle.
Well, I think you need to start teaching federal jurisdiction in addition to constitutional law. Do you ever teach federal courts?
I'm too junior to do that.
We got to teach you, get you to teach federal courts because you could learn some things.
Oh, I knew that was coming, by the way. I knew that was coming.
That's where you learn about the real Constitution. That's where you learn about, that's where the text matters. So when I was in law school at Tulane, the Attorney General of the United States at the time, this was while President Reagan was in office, was a guy named Edwin Meese. He came to Tulane to give what ended up being a pretty famous speech, but all of us who were in attendance that night thought that it wasn't that controversial, that it was kind of vanilla. So what did Attorney General Meese say? He spoke about the law of the Constitution, and the point of his speech was to say that a lot of what Josh has been saying, which is that there's a difference between the Constitution itself and the interpretations of the Constitution by the Supreme Court, and that they are not the one and the same. It's the Constitution that is the supreme law of the land. And he said, and if it weren't that way, if that weren't the case, then how would the Supreme Court be able to overrule its interpretation? So when the Supreme Court has, we all know, has rendered some terrible decisions over time. Many decisions have been wrong.
Mm-hmm.
We fought a civil war over one of those decisions.
Mm-hmm.
And sometimes the court has seen the error of its ways and has overruled its earlier decision. Now, when it overrules its decision, does that change the law going forward? It changes constitutional law. It changes Supreme Court precedent, but it doesn't change the Constitution itself. What the court decides is we were wrong about how we interpreted the Constitution earlier. We were always wrong about it. So what we're saying the Constitution means now is what it always meant. And what we had said about it before was always wrong. So Dred Scott was always wrong. Plessy versus Ferguson was always wrong. I would say Korematsu, which the Supreme Court more recently overruled, was always wrong. Why is that? Because there's a difference between the Constitution and constitutional law. There's a difference between the Constitution that we all swear an oath to uphold and the decisions of the Supreme Court. Now, does that mean we can ignore Supreme Court decisions? No. It does mean that in the other branches of government, officials don't necessarily have to agree with Supreme Court decisions, and they can test those decisions and urge the court to overrule its decisions. We know Abraham Lincoln did that. Abraham Lincoln never accepted Dred Scott as a correct decision, as a correct interpretation of the Constitution, so he did things to test it. For example, he issued a patent to a black inventor. He did things that would potentially create a case of controversy that would give the Supreme Court an opportunity to overrule a decision that he thought was always wrong. He's not the only executive who's done that, and he's not, and state officials have done that. Then that's okay, as long as you're willing to pay the price that Josh mentioned earlier. It may be that the courts are going to stick to their guns, and if a case for controversy is brought before them, they're going to say, oh no, that's not, in fact, how the Constitution should be read, and that's not the correct interpretation, and they'll adhere to their decisions, and you'll get a final judgment, and you better adhere to it, and you may be liable for damages or attorney's fees, depending on how it all turns out. In the meantime, what are all the judges of the judicial branch supposed to do? So what are federal district judges, or on my court, federal courts of appeals, or what are state Supreme Courts supposed to do? Well, the Constitution creates one Supreme Court, and it has the power to establish precedents through its interpretations of the Constitution. So, at least for the judicial branch, those precedents are binding as precedent. They're not binding in the same way that parties are bound by judgments, but those precedents are decisions that inferior court judges have to respect and follow. And you might say, well, the judges took an oath to the Constitution. How is it that they're bound by the decisions of the Supreme Court? Well, they're also bound by the fact that the Constitution creates the Supreme Court as the Supreme Court, and they're inferior courts, so they have to respect the decisions of the Supreme Court. Now, I agree entirely with Josh about his reading of Marbury. Marbury did not invent judicial review. Judicial review existed. The practice of judges deciding that a higher law, so an act of parliament, conflicted with, say, an inferior law, a local law, a royal charter, or something of that nature. That was something that English common law judges did all the time, and they would apply the higher law to the extent that there was a conflict with an inferior law. And that's all judicial review is. Judicial review decides that some law, maybe it's an act of Congress, maybe it's an act of our state legislature, but some law, inferior law, conflicts with the Constitution itself, and so the judge has to apply the superior law, has to apply the supreme law, that is, the Constitution. Now, about the word more stuff. This is where I think you need to teach federal courts. So, at the end of the day, the parties to the Alabama case in the state Supreme Court, the original writ of mandamus action, that was the Alabama Policy Institute had filed that action. Same-sex couples had actually brought a case in Judge Grenades' court, in the federal district court in Mobile. So you didn't have, it's true, there were probate judges as defendants in both, but you didn't have the same parties in both. And to the extent that some state official would be telling probate judges, you don't have to follow Judge Grenades' federal injunction. By the way, the probate judges did follow the injunction.
They did.
They knew better.
Yep.
But
Smart.
But yeah, smart. They would have been held in contempt. But the other thing that could have happened is there is something called the All Writs Act. It's part of the supreme law of the land, It empowers federal courts to make non-parties to an action parties if they're interfering with a federal court injunction. So a federal court would have the power to, Judge Grenade would have had the power to issue an extraordinary writ, potentially make someone like Chief Justice Moore, to the extent that the probate judges were following him and he was actively frustrating the injunction, make him a party to the case and issue an order for him to show cause why he should not be held.
He would have loved that, by the way.
Oh, he would have.
He would have loved that.
Until he went to jail.
He would have loved that. You were in a letter from Montgomery jail. He would have himself into a martyr. He would have martyred himself. You know it. You know it. Give me a tweet from Montgomery jail. With emoji and everything.
I will.
Judge Grenade pooped, you know.
I will leave it all alone.
Sorry.
But in any event, there wouldn't have been a problem. It's not something that would have only been resolved by the Supreme Court of the United States.
Yeah.
Trust me.
Yeah.
A federal court under the All Writs Act will have the final say.
I agree. We've done this dog and pony show a few times before, and, but I think Judge Pryor's correct. And I do think actually dragging Judge Moore into the courthouse would have been the correct way to resolve this. And if any of Judge Moore's colleagues had also issued similar orders, you could have dragged the entire Alabama Supreme Court. In that regard, the All Writs Act is supreme law of the land, and it does let a federal judge take jurisdiction over state officials that are acting contrary to federal law as she sees it. Now,
the act empowers a judge to issue all writs that are necessary
preserve the
to effectuate
Yeah.
its judgment and to preserve its jurisdiction.
Yeah.
So that's where it would have come into play. But there was no need for that at
No.
the end of the day, because all the probate judges understood that they were obliged to follow Judge Grenade's injunction,
Yeah.
and that they did so. And so I think, maybe I may have a little bit of an agreement with you,
I know,
And
I'm happy.
I think that maybe some of what was in the complaint against
Yeah.
Moore in that second Court of Judiciary proceeding kind of bought into some judicial
Yep.
supremacy theory.
That's it.
But the bottom line charge about the permanent injunction after Obergefell that Judge Grenade had entered, that was binding on all the probate judges, I don't think there's any doubt that
Yeah.
insofar as he was telling probate judges they weren't bound by that, he was violating.
not only
the
he
canons
ignored
of
it,
judi-
he didn't even reference it. I think that was the failure. He didn't even reference it.
That was a violation of the canons of judicial ethics.
And
I think the Court of the Judiciary was right. They did, when I prosecuted, I removed him from office. The second time when they prosecuted him,
They did
just
not.
suspended him without pay
Indefinitely.
for the
Yeah.
remainder of his term.
And the wrinkle
They
was,
couldn't get a unanimous judgment to remove him from office.
And it was
That's
just-
what all the political pundits said, that I would never get a unanimous judgment to remove him, but I did. I
And-
personally cross-examined him.
They
I have the DVD in my chambers. I like to show my law clerks every year when I get a new crop of law clerks. I say, let's watch the cross-examination before you watch. It's a lot of fun.
it's like Sports Center, to just watch a replay.
Well, it's in the, any of you ever been to the Supreme Court of Alabama's courtroom? It's a beautiful courtroom. Ordinarily a witness, so the Court of the Judiciary, which is a special court created by the Constitution of Alabama for judicial discipline, so it judges complaints of misconduct by the Judicial Inquiry Commission, which kind of acts as a grand jury and charges judges with misconduct. And the Court of the Judiciary then hears the trial, and ordinarily, when the judge testifies before the court, the judge sits at a table and faces the judges. And they had told Judge Moore that that's what he had to do, Chief Justice Moore, that that's what he had to do too. And he insisted that he was going to, quote, confront his accuser. That would be me. And so he picked the table up and placed it down in a position, the only witness in the history of that court to ever get away with this, so that he could face me as I cross-examined him. But it was a lot of fun.
Let's do some questions. I think we've had enough back and forth. Questions from you guys? Yes, over there.
So is there a balance between a federal judge in Mobile issuing an order to Alabama state officials and a federal judge issuing that order and then affecting somebody in another state who's not following? I mean, is there
Well,
a
that really comes into account. That's more of a question of personal jurisdiction. I mean, if you have sued someone in a federal court, wherever they may be, the question is, does the court have, personal jurisdiction over them? Can they be held into that court, and are they a proper defendant in that court? But if they're properly made a party and file an answer, they're before the court. The state lines won't matter very much.
And I think you might be hinting at the nationwide injunction issue. I think I see shares. So let me just show up. Maybe I know something at federal courts. Maybe I'll embarrass myself. But the phrase nationwide injunction is used a lot today. It's kind of a misnomer, right? Judges can absolutely issue an injunction beyond their borders, right? Let's say I have a business in Texas, but I also have a business in Mobile, right? If my company is a party to this case, you better believe it that a judge in Mobile can affect where my company is because we have contacts in both states, right? There's nothing wrong with a judge issuing a ruling beyond the jurisdictional boundaries of Mobile, Alabama, or even the state of Alabama. The debate that you read about today is what's called a non-party injunction, right? That if, again, I sue Kevin, right? We have a lawsuit. The judge can issue a judgment between me and Kevin. That's fine. What if the judge says, you know what? I want to bind everyone in this room, follow that same rule. There's a mechanism to that. It's called class action certification. The Rule 23 says you have certain commonality, certain common themes, right? You can certify a class. Maybe you got this little postcard saying,
That's almost right, John.
oh, all right, go on.
I mean, a nationwide injunction is this.
So close. So close, so close.
Close, but it's not exactly right.
Okay,
You
go on.
Tell me if you disagree.
All right.
So these cases where there's been controversies about nationwide injunctions, you'll have a plaintiff who's supposedly alleges they're affected by whatever it is that the government official is doing. So whether it's DACA, for example, right? So they sued the Secretary of Homeland Security, right? And I don't think anyone would quarrel with the authority of the judge to say to the Secretary of Homeland Security, don't do whatever it is that they're complaining about to these people who are before you.
These people agreed, yes.
That's right.
The
These
plaintiffs, yes.
Right? But you said it's a non-party. It's not really a non-party injunction. What the court does with a national injunction is it says to the Secretary of Homeland Security, who is a party to the case.
Plaintiff,
Not-
non-party, and
Yeah, that's right.
Yeah.
That's right. Don't do this to any other potential plaintiffs
Yes.
who aren't before the
Yes.
court. Now,
We-
they're
we agree.
non-parties, but the order is being directed to a party, and
Yes.
that's where the controversy.
right. It's not the defendant. The defendant is nationwide. The Secretary of Homeland Security exists everywhere, right? She has agents around the world. It's the plaintiffs who are limited in numerosity, in number.
That's right. Yeah, and if the plaintiffs had a class action,
They could certify.
they could certify that. That's exactly right. So the Secretary of Homeland Security could not do anything that would injure not only these named plaintiffs, but any member of the plaintiff class, anyone who meets that class action description.
Okay, I think we agree.
Yes.
After being chastised. All right, next.
Quick questions about the nationwide injunction. Do you think the Supreme Court's going to do anything about it? I know there's been signals, I think.
That's
Justice
probably a Josh
Thomas-
question.
Justice Thomas in the opinion last year kind of made a reference to having an issue with it, I believe.
Gorsuch, yeah.
I mean, I don't know.
Go for it.
The justices have issued some justices have issued opinions that have said, we think this is a problem. This is a kind of a relatively new phenomenon, and it's something that the Supreme Court, in the right case, needs to review. So we know that some justices have written that in their opinions.
It's going to be a hard case, though, because think of it this way. The only way the government confronts a nationwide injunction if it finds that a local injunction is proper, but a nationwide injunction is not. In other words, in this case, Trump would have to lose, but you limit it to the parties, the plaintiffs for the case. So, imagine the travel ban case, right? The travel ban's unconstitutional, but we're going to limit the injunction to the plaintiffs in this case, right? That would have an effect of like maybe 5 seconds, because we just have a bunch of other lawsuits filed to broaden the scope of the judgment to other parties, right? Or they certify a class. So it's going to be, for the court to confront it, it's going to have to be a weird case where they rule against Trump, but they find that the injunction should be localized to the parties, the plaintiffs, before the court. I think that's right. He's nodding. I think I'm okay.
Well,
Yeah, there it is. There it is.
There's a limit to what I can say.
I know.
About make predictions.
Oh, blame on
about
the
what
ethics,
courts- About what courts will rule, and I really don't know. I don't know how the Supreme Court necessarily will rule, but I would say that this raises kind of an old problem that you'll see in some federal courts case books, which is right at the beginning in the discussion of Marbury and Martin Wexler, there's a discussion about how do we view courts? Do American courts, and particularly federal courts, operate under a private dispute resolution model? That is, that they resolve the dispute of the parties before them, determine what their rights are, if any remedy for a violation of rights can be entered, what that remedy will be, and that's it. Or do federal courts supposed to operate on a public rights litigation model, where this kind of gets into the whole supremacy notion and kind of the mythology of Marbury, that whatever the court says binds all parties and all branches of government that's forth. Now, we both disagree with that as a general proposition, and that a lot of that debate is an issue in this controversy about national injunctions.
Yeah.
Nationwide injunctions.
More questions? Going once.
Everyone
Go.
had their taco mama.
Going twice. All right. Thank you all so much, and hope you enjoy the rest of your day. Thank you, sir.
All right, appreciate y'all coming.